Just a few months ago, on 25 May 2013, we marked an important milestone, the passage of 20 years since the establishment of the International Criminal Tribunal for the former Yugoslavia by the UN Security Council in Security Council Resolution 827. The decision, taken back in 1993 by the Security Council, was historic. After half a century of inaction, following the trials of Nazi leaders for war crimes and other violations at Nuremberg, the international community joined together and issued a strong response to atrocities being committed during a period of fierce armed conflict. A response grounded not in recriminations or vengefulness, but in the rule of law and in the idea of principled accountability. When the ICTY was created, many had their doubts as to whether it would accomplish all that was hoped, and whether the broader ideals embodied in Resolution 827 would become a reality. They had doubts that there would be arrests, doubts that there would be trials, and doubts that the court that they were creating on paper would become a viable institution. In the early years, the tribunal certainly faced its share of challenges, and some of those challenges persist even in this day. Some of our rulings, both then and now, have been controversial. Some claim that the tribunal's decisions have failed to give victims justice, while others question the ICTY's impact on regional or national reconciliation or its contribution to the historical record. It must be remembered, however, that the mandate of our tribunal is quite limited. The tribunal is tasked with determining the individual criminal responsibility of those who stand accused of serious violations of international law, and it may only find an accused guilty where that guilt has been proven beyond reasonable doubt in accordance with the law and on the evidence presented. And it is by paying strict and sober adherence to this mandate that in 20 years that have passed since the tribunal was founded as the first international criminal court in the modern era, the ICTY has put to rest the early doubts and arguably surpassed expectations in important ways. Indeed, many of the advancements made since 1993 in the world of international criminal justice more generally were made possible thanks to the groundbreaking example set by the tribunal. Through its decisions and judgments, the ICTY has established key precedents in the area of international criminal and humanitarian law, precedents that have not only been applied in the tribunal, but have guided the work of other international courts and judicial authorities in national, in domestic jurisdictions. The tribunal has also developed an important body of procedural jurisprudence addressing international fair trial rights and international standards of due process. But this is not the entire legacy of the tribunal. Although the ICTY is a court mandated to try individuals for serious violations of international humanitarian law, in trying these cases, our court has also prided itself in having at its core a deep commitment to and respect for human rights and for due process of law in particular. Fair trial rights, such as the right to be presumed innocent until proven guilty, and the right to a fair and public hearing, are not simply at the core of our statute, they are fundamental concerns, the import of which informs how our trials and our appeals are conducted day in and day out, and the structure and myriad of services provided by the Register of the Tribunal. Fair trial rights are the focus of a great many of our decisions and judgments, and our rulings in this regard embrace a wide range of topics, from the sufficiency of an accused's notice of the nature and cause of the charge against him, to the adequacy of the time and facilities granted for the preparation of the defense, to the availability of translation of certain documents and judgments in a language that the accused can understand. Outside the courtroom, the tribunal has crafted practical processes and procedures dealing with everything from the enforcement of sentences to the protection of victims and witnesses, processes and procedures that serve as valuable models for other international courts. And through its trials and dedicated efforts of both the prosecution and the defense, the tribunal has become the guardian of an extraordinary quantum of evidence and information concerning events during the conflicts in the former Yugoslavia, creating an archive of material that will serve students and researchers for generations to come. Perhaps more fundamentally, the ICTY has demonstrated that it is possible to try even the most complex of cases involving allegations of some of the worst crimes imaginable and brought against senior military and political leaders, and to do so fairly, and to do so not once or twice, but time and again, and importantly, ever since 2011, when the last fugitive was transferred to its custody, the tribunal has been able to claim an unrivaled 100% enforcement rate, with all 161 of those indicted by the tribunal accounted for. In many ways, the ICTY has helped to usher in a new era of accountability, an era where the clear expectation is that the international community can and will react to heinous crimes committed in time of armed conflict, as well as in time of peace, an era where the human dignity of all persons is valued, and when there is an obligation on the part of the international community to act to stop the commission of atrocities and to bring those accountable to justice and to account. The work of the ICTY has demonstrated that such action can be taken, that principles can win over impunity, and that heinous crimes can be punished, whoever their architects may be. We see evidence of the rise of this new era of accountability when we look at the international and hybrid international courts and tribunals now present on 3 continents, including the world's first permanent International Criminal Court the ICC at The Hague. And we see signs of this new era truly taking hold when we look to the growing number of cases being brought in national jurisdictions from here in the former Yugoslavia to Latin America, involving allegations of crimes committed in time of armed conflict. In reflecting on the work of the ICTY over the past 20 years and its achievements, it is easy to attribute much of what has been accomplished to the judges, the registrars, the prosecutors, the defense counsel, and the exceptional staff who have worked tirelessly to turn what was only a dream at the time the ICTY was created into a functional and fair reality. But there are others who have made the ICTY's achievements and milestones over the past 20 years possible. Others to whom I would want to pay tribute today. All that we have accomplished at The Hague would not have been possible without the sustained effort of the international community over the years. But it would also not have been possible without the tireless efforts, dedication, and courage of people here in Sarajevo and elsewhere in the countries of the former Yugoslavia. These are the people whom I wish to honor today for their contribution to the work of the ICTY over the past 20 years. First and foremost, we must recognize the important role played by individuals who have summoned the courage to come forward and give evidence about what they have seen and heard, and in many cases, about the tragic and horrifying events that they have survived. Hundreds and hundreds of individuals have traveled far from their homes to testify before our court, often being asked to speak about some most of the difficult events imaginable. Countless other individuals have likewise given evidence or statements facilitating the prosecution and the defense investigations that are so essential to the preparation and trial of a case. Without the bravery of those who have stepped forward, it would have been far more difficult for the tribunal to carry out the mandate with which it was entrusted. To try the cases of those accused of being most responsible for serious violations of international law here and elsewhere in the region. Without those men and women who have been willing to speak for all to hear and to tell personal stories of strength and horror, of heartbreak and of resilience, it is difficult to imagine that the tribunal would have been able to achieve all that it has. In other words, in a very real way, the tribunal's accomplishments are thanks not just to the diligent efforts of my many colleagues at The Hague, but to the courage and commitment of individuals here in Sarajevo, elsewhere in Bosnia and Herzegovina, in Croatia, in Serbia, and throughout this region, individuals who have stepped forward to give their evidence when it mattered, individuals who have made our work possible and have helped to bring about this new era of accountability in which we are entering now. If the ICTY's accomplishments over the past 20 years would not have been possible without the dedication and bravery of scores upon scores of individual witnesses, they also would not have been possible without the cooperation that we have received from states around the world, but especially here in the region. Without a police force of its own to conduct investigations and obtain evidence, the tribunal has been and continues to be reliant on the cooperation of states for assistance. The tribunal has likewise been dependent on states to ensure that those who have been charged with crimes before the ICTY are arrested and transferred for proceedings in The Hague. And this may be the right moment in which to express my deepest appreciation to the government of the Netherlands, our host government, which has done so much to make the operation of the tribunal day after day possible, and without whose political support we would never, ever had Mr. Mladic at The Hague, and I thank you, Mr. Ambassador. In the early days of the tribunal, some states were reluctant to step forward and offer assistance. The investigations that could be concluded and the timing of our trials were impacted by this reluctance. But over time, as the conflicts receded, as the tribunal began to demonstrate in concrete terms what it could and what it would accomplish, and as the states of the former Yugoslavia in particular came to demonstrate a strong commitment to supporting the tribunal's work, this reluctance began to disappear. States instead began to cooperate in the earnest sharing information and evidence, facilitating investigations and court proceedings, and importantly, ensuring the arrest and transfer of those accused before the tribunal. This cooperation has not only been critically important to the tribunal, it also demonstrates more broadly a commitment to the rule of law and to the international community's vision of accountability reflected in the establishment of the ICTY 2 decades ago and sets a model for other states to follow. I salute the states and the many individual state authorities and officials that have stepped forward to assist the tribunal in the fulfillment of its mandate over the years, and through their invaluable contribution and cooperation, have demonstrated their support for the goal of ensuring fair and just proceedings and respect for the rule of law. As we mark the 20th anniversary of the tribunal a few months ago, we were also completing the preparations, our preparations, for another milestone, the opening of a new tribunal, the new mechanism for international criminal tribunals, an institution tasked by the Security Council of the United Nations with taking on certain key functions of the ICTY and the ICTYR as the ICTY moves to complete its remaining trials and appeals and to close its doors. The mechanism responsibilities range from hearing any appeals filed against the trial judgments issued in the Seychelles, Karadzic, Hadžić, and Mladic cases, to ensuring ongoing witness protection and support services, and from managing the archives of the ICTY to providing assistance to national jurisdictions in their own investigative and prosecutorial endeavors. I am honored to serve as the president of the mechanism and very much hope that in the years ahead, the mechanism will build strong and cooperative relationships with the states of the former Yugoslavia. Even as the mechanism moves to take its place as the newest tribunals in the universe of international criminal justice, my colleagues in The Hague and I remain focused on ensuring the orderly, responsible closure of the ICTY, and most importantly, the completion of its mandate. But the completion of the ICTY's mandate has also been made possible in part by the actions of those in the region, and particularly those in Bosnia and Herzegovina. This is because, thanks to advances made in the capacity of the local judicial system the tribunal has been able to refer several cases of intermediate and lower-level accused indicted before the ICTY for trial in courts here in Sarajevo and elsewhere in the region. Indeed, over the years, the tribunal has undertaken numerous initiatives to support the work of legal professionals and institutions tasked with handling war crimes here in the former Yugoslavia, transferring expertise and practical knowledge. These efforts have contributed to the establishment of specialized organs for war crimes investigation and adjudication, the increased capacity of non-specialized courts to adjudicate war crimes cases, and the implementation of international standards and best developed practices within the local judiciaries in an array of contexts. My colleagues and I have been both proud and honored to share our experience with our colleagues here in the region in an effort to create and to help and to facilitate this capacity building. Just as important, however, we at the tribunal are so very grateful to the many individuals who have dedicated themselves to ensuring that local judiciaries have the capacity and tools to continue adjudicating war crimes cases in accordance with the highest international standards, even after the tribunal closes its doors. And again, I would like to express my deep admiration to Madam Kresa. We are grateful because not only have national judiciaries and countless other individuals and interested entities made it possible for the vast majority of cases related to the conflicts to be tried here in the region, thus helping to establish an invaluable local ownership of the processes at stake. They have also taken and continue to take critically important steps towards carrying the tribunal's own legacy, the legal and practical precedents it has set, the evidence it has gathered, and the experience it has gained forward into the future. And in doing all of that, they are turning one of the tribunal's greatest achievements, the opening of a new era in which accountability will be the rule and not the exception, into a reality that cannot and shall not be ignored. And I thank you.